that beneficiary is receiving public aid benefits that are dependent upon how much income or assets that child or beneficiary has. In other cases, you may have a beneficiary who's got the same disability or even greater disability, and you want them to be protected. You don't want their share to be distributed to them outright and go directly to the public aid officials as reimbursement for monies that have been paid or that will be paid in the future. So what this provision is designed to do is say, to the extent I have a beneficiary who becomes disabled in the future, again, if you have one now, discuss it with us and we can deal with that. But if for example, you've written up your trust and years down the road, you become incapacitated or you die, and one of your beneficiaries at that time is disabled and is in fact receiving public benefits through some public aid program that are dependent upon how much assets they have, this provision is designed to kick in, and the goal is to protect their distribution so it doesn't go to the state. And what it basically says is, trustee, to the extent any of my beneficiaries fit into this special needs trust section, you hold their share in a special trust. And what you're authorized to do is pay to them any comforts or care type items or luxury type items or anything that they might need in life that the state or some other government program is not already paying for. For example, if you've got a beneficiary who's in a nursing facility, maybe they don't pay for cable, or maybe they don't pay for a car, or special food related items like candy and things of that nature. The state doesn't pay for that stuff, so you want that beneficiary share to be able to be used for those types of items so they can live a comfortable, meaningful life, the life that you would want them to have. The goal is to keep that trust protected so that the state can't come in and take that money out of trust for the basic needs that the program is providing for: housing, general food, things of that nature. So that's what the provisions are designed to do. They say, trustee, you can pay money for those luxuries or those comfort items, but you can never pay money directly to the beneficiary, because if the money's paid to the beneficiary, the state program will likely take that money as reimbursement. So you're saying to the trustee, protect that money for this disabled beneficiary and pay it out to whatever service providers are needed. For example, they'd be paying the bill directly to the cable company if cable was needed, as an example. At the end of this trust provision here, it says this trust is going to terminate upon the death of the disabled beneficiary, or as provided above. There are other reasons that these trusts terminate, but the primary reason is at the death of that disabled beneficiary. In that case, you're saying whatever is left, if anything, in this disabled person's trust is to be distributed in accordance with the prior provisions related to where my trust property goes at my death. So your other beneficiaries are probably going to be in line to receive this disabled person's trust when they die. If you would like that to be handled differently, just let us know. And again, I want to stress to you, it's important that you let us know when we're preparing these documents if you have a beneficiary that's got a disability. And we need to discuss that with you so we can determine whether that beneficiary should be included within this provision. And then sometimes clients don't want that. They want them excluded from the special needs provisions so they can get their share. And it really depends on, is there a government program in place now that that beneficiary is receiving? And if they receive this money, is that program going to take their trust? So discuss that with us if this provision applies to you. Otherwise, this is included as a fail-safe for later.
More, isn't it also, it's a fail-safe for the event of government programs drying up?
Yes, that's a good point too. If the government program that your disabled beneficiary is currently on runs out of funding, and that has been known to happen, this trust is designed to allow the trustee to pay for all of the care needs of that disabled beneficiary. So they can use as much or all as necessary to provide for whatever luxuries the care program is not providing for, and basics if that care program is no longer in existence.
And it's very important for you to realize that, because 35 years ago when I started practicing, we didn't have anything like this. You either had to decide to give the child money knowing that it would probably be taken by the government, or not giving the child money and hoping that the government programs just continued. So it's a wonderful provision. Next clause has to do with trustee powers and duties. And in order to explain this, I want you to picture that you're building a robot. And it's known as this trust. And if you don't program the robot to do certain things, it's not going to be able to do it. And it's a machine you're building. So if I'm building this for my wife, for example, and I don't program it to be able to wash dishes, and she tells it to wash dishes, it's not going to wash dishes. It's going to sit there and look at her. So think of your trust as this robot. It has to be given powers. It has to be told what to do. And you're really trusting Maury and I, as we help you draw your trust, to put the powers and duties that our education tells us are needed for a trust to operate properly. You don't need these powers and duties as trustee. You own the trust. You can do anything you want with it. These powers and duties are for that trustee who would succeed you, come after you. So that's why you're putting these in. It has nothing to do with you. It's for whomever you've named to back you up, or whatever you've named to back you up. Now, we want you to browse through the powers naturally. Take that red pen that Maury alluded to earlier and mark any power that you want to question us about. We have clients who have from time to time said, well, I understand what you're doing this for my best interest, but I don't think I want that power in. Or I want to add powers. I want to give an option to my son to buy the family business. So there can be things that you add. So do browse through it. There's only about 4 pages or so. Just browse through it, take a look at them, and let us know if there's any questions that you might have. Boy, I think that brings you up again. Am I right?
Sure. The next provision we want to talk about is trustee employment provisions, and that's the title of the next section that we're going to discuss. It starts out by saying in A, any trustee may resign by giving 60 days written notice. So basically what that is designed to say is you can't force a trustee to serve as trustee. Even though you've nominated them to serve and you think they would be good at it, you can't force someone to do it. And there are a number of reasons why your trustee may resign. It may be that the family's not getting along and the trustee just doesn't want any part of it. It may be that the trustee is at that point elderly or has a disability or is sick or caring for someone in that position and they just don't have the time or the ability to devote to your trust. So they may resign. So that provision is basically acknowledging that they can do that. The next provision in here you may or may not have. When we met with you earlier to discuss your trust, we would have asked you whether you wanted to have a right of your beneficiaries to remove the trustee for any reason or no reason at all. Some of you will say, yes, I want the trustees to be able to fire, or I want the beneficiaries to be able to fire the trustee for no reason or any reason. Others of you, particularly parents with children who are the beneficiaries, you've selected a trustee that you think is appropriate and you don't want your kids to be able to fire that trustee for no reason just because they don't like them or for whatever reason. So if you've said that your beneficiaries have a right to remove the trustee, that will be your next clause. If you told us that you don't want that right, then we've simply deleted that clause and you won't have anything there related to removal. The next clause deals with appointment of your successor trustee. Now when I first talked to you about this trust, I mentioned you're the trustee of your trust during your lifetime and during your capacity. If you become incapacitated or you pass away, that's when your next in line trustee steps up. Or you could simply decide to resign just because you're tired of handling your own trust affairs and you want the next person to do the job. That's where this kicks in. You will have told us one or more people who are going to serve as your backup trustees, and we should have their names and addresses listed here. Please double check to make sure that those names and addresses are correct. Once we get through the people that you've named, we usually like to end it by saying that either a bank or a corporation or any one of your descendants can serve as trustee provided they are of a certain age. So make sure that we have that in there as well. And that's designed to be a fail-safe. In other words, if the people that you've named either can't serve or won't serve for whatever reason, you're saying, okay, there's going to be a vacancy in the trustee office, and my beneficiaries can appoint, the local bank and trust to manage this trust until it's time for distributions, or can appoint one or more of my descendants to do the job, provided they have reached a certain age that you deem as appropriate. Okay, the next paragraph in here basically says that if a trustee is going to resign or a new trustee is going to be appointed, then the notice of that is going to be given to you if you're alive and competent, or otherwise to a majority of the then income beneficiaries. So if a new trustee is to be appointed and it's not one that you've named because there's a vacancy, then a majority of the income beneficiaries of your trust are going to be tasked with selecting that new trustee. The next section deals with life insurance provision. Basically, this gives the trustee the right to hold life insurance provisions in there. They're not required to come up with the money to pay any premiums on those life insurance policies. If the proceeds are paid from a life insurance policy on you because of your death, you're saying here to the life insurance company, go ahead and pay the proceeds to the trustee, and you don't have to make sure that they take that money and distribute it in accordance with my trust plan. We put that in there to kind of take the life insurance company off the hook, number one. And number two, you don't want the life insurance company in the middle of all of your trust provisions and looking at where your stuff is going and second guessing what your trustee is doing. You've selected your trustee because you have faith and confidence in them to take that insurance money and distribute it in accordance with your plan, and that's what this basically is saying they can do. The next paragraph is very important. It's entitled Amendments and Revocation. And basically what this says is that you are in charge of your trust during your lifetime. You have the full power and right to amend this trust in its entirety or any provision in this trust. You also have the right to fully revoke this trust. If you ever want to, you can take all of your property out of trust, just like you had before you started this trust, and you can get rid of this trust. You're in full control of the trust. The only time that changes is if you become incapacitated or when you die. At that point, whatever your trust says is set in stone, and it can't be changed without a lot of expense and a lot of hassle. But for all intents and purposes, at that point, incapacity or death, your trust is set, and your trustee is going to be regulated by what you've already said. So it's important that along the way, in the future, if you want to make changes, you come in and make those changes, because you don't want to be in a position where you wanted to make a major change to this, which you're authorized to do, but you're in some car accident or something happens to you and you don't get it done. So this authorizes you to do that. The final paragraph is the closing paragraph, and it just says that Illinois law governs this transaction. And then you'll have a point for a place to date it, which will be the date of your signing appointment, and a place for your signature. And again, make sure that your name is spelled correctly there above your signature, or below your signature line. And then finally, we'll have the final page is the notary page, and you will be signing in front of a notary, and that notary will notarize your signature that you were in fact present. Now, now that we've gone through this trust, if you have any changes that you want to make, hopefully you've noted those with your red pen. You can simply call us and tell us what those changes are, if we've made a typo or something like that, or you can set an appointment to come in and have one of us read through the document with you, or read through your changes that you want to make, or discuss any portion of the trust that you'd like to discuss. I think that concludes the trust portion. The next document in your packet should be your last will and testament, and go ahead and pull that out so we can go through that. At the top it should say last will and testament of, and then your name should appear. Again, make sure we've spelled your name correctly. In the opening paragraph it should say I, and then your name should appear, of, and then your address should appear. Make this my will and revoke all my prior wills and codicils. So basically what that's saying is this: if you're doing a new will, if you have an old will that you did from years ago or even more recently, that will is no longer in existence and has no further effect once you sign this one. And those old wills and those changes to wills, which is what a codicil is, those are all revoked the moment you sign this one. Then we get into section 1, and that's the interment section. And in this section we should describe what your instructions to us were with regard to your funeral and burial. Some of you want to be cremated, in which case we will have said that in this section about cremation and how you want to have your ashes disposed of. Others of you want burial, and we will have said where you want to be buried. And we will also just make a note in here that the expenses of your funeral and burial are to be paid by your executor. If you have a lot or a monument, please let us know, or hopefully you've already let us know. We will make a note in here that you're to be buried in your gravesite. So for those of you that have lots, that's a good note to have in there, because you don't want your executor paying for a lot that you already have. So make sure you make us aware if you already have a lot purchased. And if you have a monument purchased or things of that nature, let us know that as well, and we'll make a note in here. The next section is called the personal property article. And I'm going to assume that you're a single parent and you're leaving everything to your children. It says that you give all your personal property, including jewelry, pictures, books, household furniture and appliances, clothing, automobiles, and all of your kind of personal household items that you have. You're giving it to those children equally to be divided as they decide. Now, if you've left your personal property to someone else, then we will have filled in who those people are. And we may have the names of your children here if you're leaving it to them, and make sure that we spell their names correctly. And again, I point out that it's to be divided as they decide. So basically you're saying, here's all my personal property, beneficiaries or children. You decide amongst yourselves how to split this up. I'm not going to go through, you're saying to them, I'm not going to go through and make a laundry list of certain things that each one of you are to get. However, if you have certain items that you would like a specific beneficiary to receive, we need to know that, and we need to make sure it's in your will. That's the way to ensure that that particular item gets to that particular person. If you have no preference, then this is the way it will be written. It basically is given to them equally, and they decide how to split it up. Now, if one of your, let's assume you're leaving it to your children, and if one of your children is deceased, but they leave children, you're saying that your grandchildren from your deceased child get your child's share, but your living children are going to decide what property items make up that equal share. The reason we set it up that way is we think that your children have a closer connection to your personal property than your grandchildren do. More sentimental attachment will be given to certain items by your children, and we want them to be deciding what goes where. So that's what we've stated here. You can also, if you don't particularly want to make sure that a particular item goes to a particular person, but you kind of, you'd like to see that happen, we can give you a little memorandum that you would fill out and says, I want my gold watch to go to this child or that child. If you do it that way, it's not a guarantee that it will get to that person, but it does give your beneficiaries kind of your hope that that's where that particular item will go as far as that person's share. Again, if you want to make sure that a particular person gets a particular item, we need to specifically set it forth here in the will.
Or you could do the memorandum and date it before the will.
You could do that too. But if you have specific items that you want to go to a specific person, just let us know about that, and we'll talk to you about the options that you have related to getting it to that person. We also have a paragraph in here that says that this personal property article does not include things like money, securities, chose as an action, which is basically your rights into any lawsuits that might be pending, stocks, bonds, debt, things of that nature. All of those things don't go in accordance with this personal property article. Instead, they go with the rest and residue article, which is the next article. Now, since you have a trust, which is the document we were just going through a minute ago, the rest and residue article is going to pour over to your trust. And it's just that. It's saying, executor, other than these personal property items that I might have outside of my trust, if I don't have everything else in my trust, it was probably an accident, and I intended to get it into my trust during my lifetime. I just didn't do it for whatever reason. In that case, executor, your job is to pick it up and put it into my trust. That's where my main estate plan is. That's where I want my property to be distributed. So take those things that aren't considered personal property and put them in the trust, executor. And from there, the trustee will handle the distribution of those items in accordance with my trust. Again, in this paragraph, we're going to have some quotes in capital letters, which should be the name of your trust. And as I mentioned before, it should be your name, then it should say Declaration of Trust dated, and there should be a blank there. Again, we will fill in that date whenever your signing appointment is. And that's why I mentioned it's kind of important for you to try to keep your signing appointment once it's set, because we will in advance fill in that date for you. That's all for me.
The next clause is entitled Survival Article, and I'm just going to read it. It's a very short article. No person named or described in this will shall be deemed to have survived me unless he or she is living on the 30th day after the day of my death. And that's more or less an administrative article. It's to stop the idea of multiple expenses where we're administering your estate and a beneficiary dies within 30 days, and now they're administering that estate before it gets down to the next level of beneficiaries. And you more than likely have said to my child, and if a child dies before me, it goes to their descendants. So rather than clear it through your estate to get it to that child who is deceased, and then that child's estate administering the same assets to get it down to the next level, you're saying a 30-day survival. And that's particularly valuable in the car accident. or the storm, or vandalism, where your life's taken and then that of a beneficiary is soon thereafter. So hopefully you're never faced with that. It's just an administrative article that we put in to try to save expense if you're ever in that situation, or your estate's in that situation. The next clause is the executor appointment and powers article. And before I get into that, I want to get you thinking with me as this article is explained. There is no executor of your estate unless there's probate. If you have followed what Maury and I have advised to you, and other staff members have advised to you with regard to the use of your trust, there's not going to be any probate. So this clause is not going to be operative. If you have the limit, and the state from time to time sets a limit for probate, if you have less than this limit, there is no probate. If you have more than the limit, there is probate. So if for some reason, unknown reason, you have outside the trust above this limit and is required to have probate, then this is going to be operative. So keep that in mind. If you follow the directions that we've given you, no probate. If there's a mistake, as Maury said, there's something outside the trust and an executor is going to pick it up and put it in the trust, that's still probate. So keep that in mind. You're going to have a nomination of an executor in the very first paragraph of that article, and as Maury has indicated throughout our presentation, check the name, make sure it's spelled correctly, the addresses are correct. You may have a successor executor, again, check the name, check the address, make sure things are spelled correctly. Mark any changes that you can see need to be made in the margin of the will. The next clause, lettered A, is kind of a general instruction to your executor, and more or less absolves them from following the instructions that you give here. That beneficiaries can't come after them if they followed your instructions. You're directing the executor to pay from the residue of the estate all of my debts, my expenses of administration, so on and so forth, to get through probate, pay the expenses of probate. You're giving the executor the power under Internal Revenue Code Section 2207 to recover federal estate tax that is outside of the probate estate on assets that are outside the probate estate. For example, you have a life insurance policy, it's a $150,000 policy, and you've left it to a named beneficiary. It's outside of your will, but you're allowing your executor to go get from that beneficiary of the life insurance the amount of the federal estate tax that's attributable to it and bringing it back into the estate. It can be a very important provision. You're allowing the executor to ratably apportion among the beneficiaries under your will the expenses of the will, similar to provision that you have in the trust that Maury explained earlier. So everybody's paying their fair share. If you want something other than ratably apportioned, for example, you say, well, you know, Roy, you know, Maury, I'm fine with the residue of my estate paying all the expenses. Well, that's okay with us, but we're just putting in what we think is most fair for you to look at least in this draft. You may want it equally paid. I don't care what each beneficiary gets, everybody pays an equal amount of the taxes. So keep that in mind. If you want something different, let us know. And finally, in that clause, you're saying, executor, you make the elections under the income tax laws, the gift tax laws, the death tax laws that you feel are best for my estate situation. You're going to have knowledge of what's going on in my probate estate. I trust you to make the best decisions. Now that means you've made a very educated decision as to who your executor is, and that you trust them to hire help if they need it. It's highly unlikely that the executor you appointed is going to be an expert in gift tax, death tax, and income tax, unless they're a CPA, and then specialized CPA. So you want them to hire help, but once they've heard the advice of that professional, you're saying you make the decisions and I absolve you from liability. That's an important provision. Otherwise, you could have executor a little bit